Nearly 13 months, 13, since the FBI searched Donald Trump's Florida Beach Club for classified documents. Today, we got new insight into what led up to that search. NBC News has confirmed that in May of last year, Trump was warned by one of his lawyers, Evan Corcoran, that the FBI might very well search Mar-a-Lago if Trump didn't comply with a grand jury subpoena requesting the return of those classified documents. ABC News was first to report on a warning that Mr. Corcoran gave to Mr. Trump, which Corcoran documented via voice memos on his phone. According to those voice memos, which NBC News has not yet heard nor seen transcripts of, but through a source familiar has confirmed the existence of, Mr. Corcoran explained to Mr. Trump, if you don't comply with the grand jury subpoena, you could be held in contempt. And there's a prospect that they, as in the government, could go to a judge and get a search warrant and that they could arrive here. That is here, as in Mar-a-Lago. In other words, these recordings appear to show that Mr. Trump was very well aware that a search of Mar-a-Lago was likely, which was not at all evident from Trump's statements the week after that FBI search when he sort of whipped up anger and indignation at law enforcement on Truth Social. There is no way to justify the unannounced raid of Mar-a-Lago. Without notification or warning, an army of agents broke into Mar-a-Lago, went into the same storage area, and ripped open the lock that they had asked to be installed. A surprise attack, politics, and all the while, our country is going to hell. Remember when your lawyer told you that might happen? Anyway, also today, we finally got some insight as to why Trump's lawyers didn't take a tougher stance with their client. According to the recordings, Corcoran met with another lawyer who warned that Trump was just going to go ballistic if Corcoran pushed the former president to comply with that subpoena. In the end, Trump did not comply, and the rest is history. Joining me now is Mary McCord, former assistant U.S. attorney in Washington, D.C., and former acting assistant attorney general for national security at the DOJ. She is also, of course, a co-host of the invaluable MSNBC podcast, Prosecuting Donald Trump. Mary, thanks for helping me understand what's happening here. These voice memos, the Trump campaign is saying this is part of attorney-client privilege. You have no right to this. Is that fair? And how useful are these in the case that Jack Smith is making?
Well, I think it's important to remember that these voice memos were the subject of a dispute that was litigated in the District of Columbia, the District Court for the District of Columbia, back when Evan Corcoran, Mr. Trump's lawyer, of course, during some of the Mar-a-Lago incidents, so when you were just referring to in the opening, when the Jack Smith and the grand jury sought to subpoena Mr. Corcoran to testify. He asserted attorney-client privilege, not only over his testimony, but also over documents and things like that. The government took that matter to the chief judge of the district court in the District of Columbia and argued that the attorney-client privilege should be pierced because there was evidence to suggest that Mr. Trump was actually perpetrating a fraud on his own attorney. He was actually trying to use his attorney to commit a crime. The District of Columbia judge agreed with that, and that is why Mr. Corcoran then did testify in front of the grand jury and did supply these voice memos, which at least some of which were seen by the grand jury, because parts of these same voice memos appear in the indictment that was returned. So they're not new. We just have more evidence or more accounting of some of the details of those things at this time.
Right.
How important are they? That clearly they're very significant. They show Mr. Trump lying to his attorney. And some of the new things we got today show that it was actually when his attorney, Mr. Corcoran, said, if you don't comply with the subpoena, the government may get a search warrant. It was in response to that Mr. Trump said things like, wouldn't it be better if we just said we didn't have anything? We know now that not only did he then spend 2 weeks, Mr. Trump, directing his aides, Walt Nauta and Carlos de Oliveira, to move a lot of boxes out of the basement storage unit and many fewer boxes back into that storage unit. We know now that maybe wasn't just to avoid Mr. Corcoran seeing all of the classified and being able to go through it and provide to the government the response to the subpoena. but maybe was to secret those documents away so that if there was a search warrant, they wouldn't be found.
Right. It almost establishes that he was acutely aware that a search warrant might be on the horizon and then did everything in his power to make sure certain documents were not found. Is it strange to you that Evan Corcoran, who took these first of all, the fact that Evan Corcoran was making voice memos about his client behaving at best erratically, at worst unlawfully, is that a normal thing in terms of counsel? And secondly, by all the reporting we have, Evan Corcoran is still engaged as a legal advisor to Donald Trump. Is that bizarre?
Yeah. So, in terms of the voice memos, it's not unusual for an attorney to memorialize their contacts with their client, right? They want to keep a record of the conversations they had with their client, any advice they gave to their client, how their client responded. That's important not only because, they have this relationship, they want to make sure it's memorialized just so that they're able to substantiate that they were doing what the client instructed them to do if there's ever a dispute, but also, of course, to, CYA, right? To protect himself when what he was experiencing clearly there was indications of Mr. Trump trying to really solicit him to hide information from the government when Mr. Corcoran well knew, he's a former prosecutor himself, the government had subpoenaed these documents, they were entitled to them, and the result of noncompliance might be contempt or might be a search warrant. So I think keeping the voice memos is not particularly unusual. I do think it is really unusual that Mr. Corcoran is still representing Mr. Trump. Now, not in the Mar-a-Lago matter, but apparently still in the January 6th related indictment that was also brought by Jack Smith, this one brought in the D.C. District Court here in the District of Columbia. Now, in that particular case, it's a conflict or an apparent conflict that Mr. Trump can waive. So if he wants to have Evan Corcoran, knowing that Evan Corcoran is likely to be a witness against him in his trial in Mar-a-Lago, he can waive any conflict and say, no, I still want him to represent me. Now, why does he want to do that? That's what kind of makes me concerned, because is he trying to do that to try to somehow pressure Mr. Corcoran not to give truthful testimony in Mar-a-Lago because he's paying Mr. Corcoran to represent him, or his PAC or somebody's paying Mr. Corcoran to represent him. And I believe Mr. Corcoran's got a lot of money from him. Now, all of that said, if Mr. Corcoran says something different in a trial in the Mar-a-Lago case than what in those voice memos and those records and recordings, then he's going to get impeached with that and have to explain what the change is about.
Voice memos have never been so critical as now. Mary McCord, the great Mary McCord, thanks for your time tonight.
Thank you.